For the period that the injunction from the High Court, the permanent one,
that is so,
and the order or the judgment of the court was pending, he had taken steps. Which steps allowed him to continue to be in Parliament, which allowed him not to obey the judgment? He had filed an appeal, and he was also seeking to stay execution. So within that period, he was not disobeying anything, was he?
He was. As a matter of law, the filing of application for stay does not operate as a stay.
Stay of execution.
That is so. It does not operate as a stay. Ex parte further. I don't want us to be talking too much law on this platform, but the point of the matter is that if the court has made an order, the order ought to be obeyed. And indeed, if you have filed an application for stay of execution of that order, the court ought to rule. You cannot take a license from the pendency of an application for stay as itself a stay of the order to enable you do things in direct disobedience of the order. So that's how complicated this matter is.
If it does not operate as a stay,
yes,
then you'll be overreaching the courts.
Naturally.
Because the issue for the court to determine, you would have gone ahead to implement it. So what is there to stay? I thought that stay of execution, as we understand, once you file it, it stays the hand of the one who is supposed to implement the judgment until it has been determined.
If you take that view. But
Okay.
I will say, if you take that view, that every time that you file for stay of execution, the order from which you are seeking the relief is naturally or automatically stay. I may disagree with
Once you are served with it.
Once I'm served with it. The Supreme Court itself has said that the mere fact that you disagree with an order, even if you have applied for stay, does not give you the relief. You must still ensure compliance. But like I'm saying, I don't want us to be arguing this point. But even then, it breaks down at the point where your appeal is struck out. Because other than that, we have a fiction of dependency of processes and gymnastics and so forth and so on. If you appeal from which, or in respect of which your application for stay itself was pending, is struck out, would we, in fairness, say that you've got something before the court? There is absolutely nothing. So indeed and in fact, what was really happening was the fact that by resort to filing of all kinds of processes, the applicant, I'm talking about the honorable question, was giving himself a new lease of life by filing all these.
If the law affords him, why not?
No, the point of the matter is that they were legally defective. Defective in the sense that once your substantive appeal, I'll grant you an agreement that, of course, if he had filed, that in fairness to him, he ought to. But what up to the point that his application is, I'm talking about the appeal itself, was struck out.
That's very recently.
And yeah, very recently.
From the point he was struck out, as we understand, he had been asked by his party people not to participate in the House.